Welcome back to Australian Patent News. Today I'll be talking about provisional patent applications. John Baxter will be giving the third part of his presentation on licensing term sheets, and I'll be describing what a patent attorney is and does. Provisional patent applications, what are they and how do they work? Well, a provisional patent application carries out a very important role. It establishes an international filing date for your idea. Patent attorneys call that a priority date. The international filing date means that from the day the provisional patent application is filed, you can claim that date, not just in Australia, but in any other country down the track, as the date at which you're laying a stake to the idea that you're claiming the invention is yours. So a provisional patent application lasts 12 months. And during that 12 months, you can do a number of things. You can carry out a patent search, and you can modify your specification to get it ready for the next stage. So let's have a look at each of these three aspects. Firstly, to carry out a patent search, why would you do that? Well, patent searches are used to have a look to see whether an idea is new. The most comprehensive patent search can get carried out at an affordable price is that done by IP Australia, the Australian Patent Office. The international type search service IP Australia offers is one that takes about 8 weeks and, taking into account attorney fees, costs a little over $3,000. Now, the catch with an international type search is that it needs to be carried out on the basis of a filed provisional patent application. That is, you can't just request IP Australia carry out a search without having first filed the actual provisional patent application with IP Australia. So we've filed our provisional application here. We've requested an international type search to have a look to get IP Australia's view on whether the patent application is novel, which is one of the key requirements in patentability. And coming up towards the 12-month term of the provisional patent application, we can then modify the original document so that the application that's filed at the 12-month point not only takes into account the original disclosure, but also takes into account any other developments you've made to the idea throughout this period of time. Now, those developments are incorporated into a new specification, effectively a modified version of the original specification, and that is filed at the 12-month point in either one of two types of documents. It could be filed in a PCT international application, which is an international patent application that reserves your right to file in a whole range of countries for another 18 months, or the modified patent specification could be filed in a direct convention application. A convention application is a type of patent that is linked to your original provisional patent application via the Paris Treaty. The Paris Treaty allows foreign patent applications filed within 12 months of an Australian patent application to claim back to the original filing date. So at the 12-month point, they're your two main options. Of course, in terms of filing in Australia, you've got some options there too. So you could file a standard Australian patent application or an innovation patent application. They're the two types of Australian patent applications you can file, and you can find out more about those patent applications in our other video blogs. Well, thanks for listening into my discussion about provisional patent applications. Of course, if you have any questions, feel free to contact myself or the team.
Hi, I'm John Baxter from Baxter IP, and I'm talking about technology licensing. In this week's blog, I'm going to be talking about how we define the license term and the license performance, and also the IP provisions of a license agreement. The maximum term of a license is normally arranged to correspond to the last relevant intellectual property right to expire, normally the last to expire patent. And in many license agreements, the term can effectively be extended by appending improvement patents to the agreement. But it should be noted that in some jurisdictions it is difficult to extend a license based on know-how only. So the message here for a licensor is to maintain a continuous feed of patents, improving on the original product, process or method. For example, improving the manufacturing process to lower cost. This not only provides much better multi-layered IP protection, but also in many cases can extend the actual term of the license agreement. It is also very important to ask which terms in the license agreement need to survive after the term has expired. For example, you may want the confidentiality clauses and a few other key clauses to inure beyond the term of the license agreement. Also, it is vital to determine which conditions should trigger early termination of the license before the end of the maximum term. Again, you need to ask which terms in the license agreement need to survive if the license agreement is terminated early. Importantly, you need to also decide on the performance criteria that are required to be met by the licensee over the term of the license agreement. This is normally particularly relevant for an exclusive license. For example, this can be time-based, revenue-based, cumulative volume-based or annual volume-based. Any exclusivity should be at least forfeited if the licensee fails to meet the performance criteria. At the other extreme, early termination of a license can be triggered. When drafting an exclusive license agreement, it is vital that hoops are provided through which the licensee must jump on a regular basis to maintain this exclusivity. A license agreement should spell out the technical assistance that is required to be offered by the licensor to the licensee and any additional fees that are to be paid for this technical assistance. Such fees are normally additional to the basic license fee provisions and are usually based on an hourly rate plus travel costs and other out-of-pocket expenses. The mutual confidentiality obligations the licensor and licensee need to also be prescribed. The funding of the IP prosecution and renewal costs of the licensor during the term of the license needs to be spelled out. This is particularly relevant for an exclusive license where all such costs are normally met by the licensee. Also, the terms of the funding of any related IP infringement suits initiated by the licensor or any related IP invalidation trials brought against the licensor during the term of the license needs to be specified. Again, this is particularly relevant for an exclusive license where the licensee is expected to join in such actions. Importantly, what also needs to be predetermined is the ownership of the IP associated with any improvements relating to the licensed product, process or method made by the licensor, licensee, or the licensor and licensee jointly during the term of the license agreement. Will this new IP be appended to the license agreement under the current terms? Or will relevant new terms be agreed in the future? Or will the incorporation of new IP extend the license agreement? Lastly, any requirements for use of the licensor's trademarks needs to be pre-agreed. A licensor may stipulate the use of trademarks of a certain physical size at certain locations on equipment. Also, markings regarding the applicable patents and patent applications are sometimes also stipulated to be put on equipment. Tune in next week where we'll talk about how we handle joint developments and also other legal terms within a licensed agreement.
So today I'm going to be talking about patent attorneys, who we are and what we do. A lot of people think patent attorneys are lawyers. Easy to get the two confused since attorneys in most countries around the world means lawyers. But in fact in Australia we're two separate professions. Patent attorneys in Australia have both a technical background, such as an engineering or science degree, and a legal background. So for myself, I've done a Bachelor of Engineering and a Master's in Intellectual Property. And so with those two skill sets combined, we have the skills to prepare patent applications for technological innovation. On a day-to-day level, our patent attorneys prepare patent applications, describing inventions. We file those applications and prosecute them, which means we take them through the examination procedure and attempt to have those patent applications granted or if they're a trademark application, registered. Lawyers, on the other hand, are involved in litigation of IP rights, preparation of license agreements and preparation of IP assignment agreements. So you can see patent attorneys and lawyers work very well hand in hand. Patent attorneys handle prosecution of IP rights, lawyers handle litigation of IP rights, and in many countries the two professions are really merged into one. That is, lawyers do the lot. So if you're an innovator with a new idea, the place to start is with a patent attorney. We'll be able to guide you in the right direction in terms of all the different services you need to get your business off the ground.